4A, 5C, 6A, 7C, 8D for dog, 9D for dog, and 10C. For Chapter 11, the homework answers are number 1, C, 2D for dog, 3D as in dog, 4C, 5A, 6B as in boy, 7D dog, 8D as in dog, 9C, and 10C. Again, Chapter 11 homework was number 1, C, 2D dog, 3D dog, 4C, 5A, 6B for boy, 7D dog, 8D dog, 9C, and 10C. Before there's any questions on the homework, let me make some brief announcements. Number 1, as always, there is no recording of the classroom. The Real Estate Commission of New Jersey forbids any recordings, photographs, audio, video of our pre-licensing course. Just remember that. Number 2, there is no posting of any links on our chat conversation. If you have a link you want to share with the class, you need to clear it before class with me because I won't allow them. And if I see somebody doing that, guys, I don't care if it seems innocuous or anything, but we've had problems with the past, people thinking that they're posting very innocent things, but they have malware and infectious stuff, and it bogs down our system. We have to clean out it's all kinds of problems. So please don't post any links on our conversation tab. Obviously, no foul language during our discussions would be very much appreciated. If you're having connection issues, number 1, close everything else down on your tablet, laptop, PC, whatever you got running, phone, whatever. Close everything else down. This demands a lot of bandwidth, and if you're operating other programs, it can soak up some bandwidth and have spotty communications. So number 1, close everything else except this program. Number 2, if you're still having issues, there's a refresh tab right up by your address bar. It's like a little circle with an arrow on it. Click that. You'll have to register to come back in, but it won't disturb you and it won't lose any time, and you'll have a much better connection. If you have administrative questions like, what chapters are we on? What day is today? When do I get this class? Where do I find that? Where's homework? How do I register for tests? How do I track my hours? All that stuff, you can go to recareercenter.com and look it up. Or just wait till noon when one of our admin staff gets online and talks about these things with you, and we'll do a Q&A with you. They'll answer all your questions. Please, however, be courteous because they're only going to be available for about 15 minutes. So if you go away and do something and come back and start asking questions, chances are they've already answered them 1 or 2 times, and they're not going to want to repeat them constantly. So, also, if you have other questions about real estate of topics that we're not discussing during the day, you can always stick around after class. I always hang out and I'll make myself available to any questions you have. I will always, and usually always do, post my email address at the end of the day. If you want to contact me for some reason, I will at least respond to your inquiry. We have breaks during the day. We have a 10:30 break for half hour, 12 o'clock break for 1 hour, and a 2:30 break for 1/2 hour. And as always, I always advise that everyone pre-read your chapters before you come to school. You will find you'll be much more knowledgeable. You'll have much more comprehension and understanding of the topics, and you won't waste the class time with silly questions that probably would have been answered if you read the chapter. So if there's any other questions or any questions about homework, now's the time to ask. Was there any questions? Can you read off answers for questions 1 through 4, chapter 10? Well, you should have been here, but did you have any specific questions on any of those responses? Let's see, chapter 11, number 2, why D not C? Well, let's go to chapter 11, number 2, and look. Chapter 11, number 2, to be legally valid, a contract of sale must And let's see, accompanied by earnest money, that's not required. Witnessed by a notary, that's not required. Acknowledged by parties to the contract, that's not required. Negotiated between competent parties, that is required. So the only answer is D. Okay, Chapter 10, Question 1. Let's see what Chapter 10, Question 1 is. When a broker has an exclusive agency listing, the broker may wind up with splitting commission with the selling broker. Correct. Because remember, an exclusive agency listing allows one broker to list the property, advertise it, and cooperate with other brokers through the multiple listing service. And if another broker sells it, then they split commissions. B is correct. And just the answers, please. Well, what question do you have? Did you have a specific question in mind? Oh, Donald, do you want me to review things? No, again, please, guys, we start at 9 o'clock and we do the review. Did anybody have any other questions or questions about specific questions on the homework? Okay, not seeing much. Let me move on and moderate the conversation. We'll start our discussion with Chapter 12. All right. So, at the end of Chapter 12, you should be able to explain characteristics of 4 leasehold estates and describe standard lease provisions, including various forms of evictions, effects of truth in renting, and Americans with Disabilities Act. You'll also be able to comprehend and discuss differences between types of leases, as well as identify functions of a property manager. All right. So if you were with me last week, last Wednesday, we talked about freehold estate interests in real property, ownership interests. Today, we're talking about that other topic, the less than freehold, also known as leasehold estates, or estate interests in property that you do not own. So first of all, we have to understand, what is a lease? A lease is a contract as well as a conveyance of rights. An owner who owns property has certain rights of ownership. We talked about those last week. However, as a tenant, until you occupy a structure, you don't have any rights to that property. It's not yours. But by a lease, a written document, some of those rights an owner has is transferred to the tenant. Now, you don't get all the rights the owner has. You only get a couple of them. You have the right to possess the property, to use it for any legal means. You have the right to quiet enjoyment. You have the right to privacy. You have the right of excluding others from using the leased property that you occupy. You don't have a right to sell it or sublease it or assign it to somebody else unless the owner agrees. But he certainly wouldn't want you to sell the property. It's not yours to sell. So knowing that you have some rights, they're for a temporary period of time. You're leasing a property. You have an interest in that property via the lease, but it's temporary. It's not forever. So the tenant, the lessee, receives the rights from the owner or the lessor for a specific period of time. Therefore, a lease contract, since it is a contract, and I said it's also a conveyance, meaning it transfers some of those property rights. In other words, you could call another word for a lease is a demise. D-E-M-I-S-E, demise. Therefore, the lease is both a contract and a conveyance. Does anybody have any basic questions about the introduction of what we're talking about today? I'm not seeing any questions. Oh, there is, so I'll hang on. Polly, welcome back. Hope you had a nice weekend. Oh, no questions. Okay. Then let's move up. Maybe Polly does have a question. Hi, yes, okay. Then let's move on. All right. Now, There are four types of leasehold estates, or four types of possessional rights a tenant may have in a lease. The first one is called an estate for years, meaning this, by definition alone, an estate for years says one that has an expiration date. Therefore, the lease that you sign, if it has a definitive expiration date, it is known as an estate for years. And if you are a tenant under an estate for years, again, you have a specific beginning and ending date to the term. There's no notice requirement from the landlord to the tenant or tenant to the landlord of an intent to quit. Therefore, both must be aware of the expiration date, so when it comes up, the tenant moves out, the landlord has another tenant ready to move in. However, I was doing a property management class this weekend, maybe one or two of you were with me, and I told the practitioners that property managers' best practice might be that if a tenant is there under an estate for years, they should give a minimum, let's say, of a 3-month notice, though it's not required, just to find out, Mr. Tenant, what are your plans? Because you're thinking of staying, I can write up a new lease. We'll have it in effect as the day the old one it terminates, and you can continue living under a new lease and arrangements or whatever. Or if you're going to be leaving, at least let me know then, because then I can plan on interviewing and getting another tenant ready to move in when you move out. So again, no notice period is required under an estate for years. However, you may just want to touch base with your tenant, or if you're the tenant, just might touch base with the owner and say, hey, I know my lease ends at the end of December. I'm wondering if you'll allow me to stay for another year. And if so, is there a new lease? Can I keep functioning under the old one? What's going on? That way, the owner or the landlord or property manager will know if you're going to be moving out or not. Any questions about an estate for years? Not seeing any questions, then let's move on. The second type of leasehold estate is known as a periodic estate, or from period to period. Many people refer to this as maybe a month-to-month lease. What it is a lease, it's probably in writing, that says you have the rights to occupy this unit for a 30-day period, which is repeatable or renewable automatically until you call it quits. In other words, you are there as a month-to-month basis. And in order to give notice on a month-to-month basis, landlord or tenant must give a 1 month's notice. If it was a day-to-day periodic interest, then 1 day's notice. Week to week, 1 week notice. If it's longer than a month, however, let's say it's quarter to quarter or year to year, then the maximum notice period under a periodic estate is 90 days or 3 months. So once again, an estate for years has a definite beginning and ending date, must have has no requirement for notice. A periodic estate is from period to period, let's call it month to month. And if it's a month to month, then you must give a month's notice. And again, whatever the period is the notice period. Unless it's longer than a month, then it's 90 days maximum. Any questions on that? Good, not seeing any, then we'll move on. The third type of estate or leasehold estate is a tenancy at will. A tenant at will is someone who has a lease that may have expired, but the tenant stayed and keeps paying, and the landlord accepts. Therefore, when's that tenant going to leave? Or if they ever will leave? Nobody knows. However, in a tenancy at will, the tenant or landlord must give a 90-day notice to quit, 3 months. Because we don't know how long you're staying. It could be years. but we need to know 3 months in advance whether you're going to be staying or leaving. So if you're going to stay, then we'll just keep it open. If you're going to quit and move out, then we need to know that because we want to get another tenant lined up ready to move in when you're done. A tenancy at will has no definite termination whatsoever and can be terminated by death of the landlord or the tenant. I don't know if you noticed on the previous ones, doesn't say anything about death or notice or anything like that. So under an estate for years, if someone were to die, their lease is still valid because they may have estate members still living there. So just because the named party on the real estate package, the occupancy, has died, doesn't mean the tenants have to move out because their estate still exists until someone notices the landlord. Then it will end. A periodic estate, it's going to be over in 30 days anyway. So if you die, guess what? Your death was the 30-day notice. And under a leasehold estate, it automatically terminates upon the death of the landlord or the tenant. So we named 3 types of estates so far. Estate for years, definite termination date, no notice. Periodic estate, no definite termination date. The period itself is the notice period unless it's longer than a month. Then it's 90 days. A tenancy at will, no definite termination date, 90-day notice requirement. And then there's the tenancy at sufferance. Tenancy at sufferance is the lowest recognized interest in a real property. This is someone who probably may have had a legitimate lease that moved in, but by virtue of the fact that the lease is expired, not renewed, or they violate terms and conditions of the lease, or they don't just pay rent anymore. They're in default of their lease arrangements. So if they originally had a lease and then stopped paying rent, they're a tenant at sufferance. If they were a legal resident using a lease and the lease expired and then they stopped paying rent, they're tenant at sufferance. If they were a tenant and they violated the terms and conditions of the lease and the landlord said cease and desist and they said no, then they can be evicted as well because their rights are forfeit because they don't abide by the terms and conditions of the lease. And there's obviously no notice period because they're already living there illegally against the owner's wishes. And the only way to get them out is through a court process known as eviction, which we will talk about substantially later. So of these 4 estates, leasehold estates, did anybody have any questions on what they are or the differences? I see a couple folks typing, so I'll hang on. We'll talk about it later, Dave. We're going to talk about eviction. Anybody else? I thought I saw several people typing, but maybe I'm mistaken. Chapter 13 is being held after 1. Well, when we're done with chapter 12 is when we start chapter 13, John. That could be before lunch or after lunch. We won't know until we're over with chapter 12. Most likely it'll be sometime this afternoon. I don't have a time frame for you. Okay. Well, if you want to repeat 12, it won't hurt you, but you don't get extra hours because of it, because you already did it. So no worries. Anybody else with a question before we move on? Okay, not seeing any. Let's move on. So what are the standard lease provisions, or what would be essential for a valid lease to be conveying interests? Well, there's a few things we have to talk about. Number 1, the tenant and the landlord must have a capacity to contract. Now, I used to always, I don't always anymore, I almost never do this anymore. I used to always answer up and say, what's competency mean? And I get all kinds of crazy things. Well, here's the thing. Competency in our aspect here, looking at it as realtors, is the ability to perform on the contract. Friday, we talked about essential elements of the contract. Competent parties was one of those elements. A lease must have a competent party. 18 years of age or older is an adult. If you're emancipated under that age, you're an adult and you're a competent party. Financially capable of performing on the lease would make you a competent party. Strong credit, the ability to pay your bills, qualifying through a background check, credit check will make you a competent party. So you have to have the ability to perform in a contract to be a competent party. And when leasing property, you want all parties to the contract check for competency, and those who are competent will be named as a party to the contract. So that's the first thing, that the parties must have the ability and right to perform on a contract. Then there's a demising clause. Words of action that say, I rent, I lease, I let to you, Mr. Tenant, the following property. Words of conveyance that mean for a temporary period of time. Then there must be a description of the premises. Usually, if it's a single family home, a street address with a lot and block number would be sufficient. But if it is an apartment in a building, usually the street address along with the building number and apartment number would be adequate. So these are the kinds of things that have to be in the lease so far. Capacity to contract, demising clause, description of the premises. And then there has to be a clear statement of the term. How long will you be occupying the property, Mr. Tenant? I need it for 3 years. Do you want to sign a 3-year lease then? We could do that. And if so, then there's a definite beginning and ending date, makes an estate for years, which means no notice period is required. So it must be clear and concise, the statement of the terms of the lease. How long is it? Also, must be very clear and concise about the rent and how it's to be paid. The rent on the unit is $750 a month. The rent on this unit is $4,300 a month. The rent on that unit, $7,000 a month. Which one do you want? I want the $7,000 a month. Okay. So let's look at the statement of the terms and the specification of rent. It is for a period of 1 year. It is $7,000 a month payable on the first of the month every month. The landlord grants you 5 late days or grace period in which you can be bringing the rent payment in, and no, you won't suffer a penalty. But if it's after 5 days, and you suffer a penalty of X% or dollar number. If you stop paying rent, the landlord has no option except then to take you to court and evict you. So a clear statement of not just the term, but the terms and conditions of your rent and how it's to be paid. Another thing that has to be said, and this is a court case that happened earlier this year in the state of New Jersey, is that the state of New Jersey actually had a petition or a suit. Actually, it was a suit by a tenant against the landlord, because the landlord required that the tenant in all his buildings pay through electronic transfer of funds. The tenant said, I don't even have a bank account. How am I supposed to pay ETF? The landlord said, you're now required to have a bank account so you can pay me electronic transfer of funds. He sued the landlord in tenant court. And the tenant's court sided with the tenant and said this to the landlords. In New Jersey, landlords cannot demand a one and only way to pay rent. It is whatever the tenant wishes to do. So if they want to pay electronic transfer of funds, that's adequate. If they want to give you a company check or personal check, that's adequate. If they can give you a certified funds, that's good too. A money order or cash is adequate. So you can't limit a tenant's ability to pay his rent by saying only one way. It's whatever the tenant wishes to do, that's adequate. There's a lot of people that deal in cash. Why should they be prevented from occupying spaces because they don't have a bank account. So that was earlier this year. The tenant courts have decided that. And now another thing, I said a lease usually has to be in writing. Remember I said that? Well, here's the thing. If it's less than 3 years, then no, it doesn't have to be in writing. However, if you're going to be getting your real estate license by virtue of this course or whatever you're going to do, if you become a real estate licensee, then any and every agreement you enter into must be in writing, no matter if it's for 1 day, 3 weeks, 1 year, 2 years, 10 years, any agreement you get into. If it's a lease agreement, if it's longer than 3 years, has to be in writing. But even if you're a licensee, it doesn't matter about the time frame, because every agreement you enter into must be in writing. And because it's in writing, all parties to the contract must sign the contract. Yes, there is an exception for up to 3 years that infers that no real estate licensee is involved. But because of the licensing laws, because you hold a real estate license, any and every agreement that you enter into must be in writing. Questions, anybody, about what is required for a valid lease? Okay, no questions. Okay, fine. Let's move on then. Maybe we'll be done before noon with chapter 12. Nobody has questions. All right, now, typical lease provisions. What has to be in a lease that's typical? Well, obviously, conveyance of the property to the tenant for a temporary basis for any useful purpose that is legal. So the tenant has the right to use the premises. But it's for a legal purpose, not for illegal purposes. Tenants don't have rights to say, I can do anything I want to the property. They don't. They have to do whatever is legal. If it's something illegal, they could give up possession of the property because they commit an illegal act that's not allowed. Now, don't get me wrong here, guys. People do stuff all the time, and landlords typically don't know about it. And that's the way it is. However, if someone's doing something blatant that is against the rules and regulations of the house or the building, or violates the terms and conditions of the lease, then a tenant has to be confronted about the issue because it's illegal. They can't be doing what they're doing. I had a situation years ago where an upstairs neighbor on a 4-story building said, hey, the building's really hot. I'm like, yeah, it's a really nice place. No, it's hot. Well, it is July, of course. No, it's really, really hot. I'm thinking, holy crap, I hope there's nothing smoldering. So I rode over to the property. And on the first floor, everything seemed too cool. Second floor, everything was cool. Third floor, it was warm. And I started walking around and I could identify the apartment because I touched the door and it was warm, where all the other doors are, neutral. So I knock on the door and this woman opens the door and this blast of tropical air of 100 and some degrees just hits me like, boom, holy crap. And then I look and she's got this rubber sweatsuit on. There's about 12 women in her living room on yoga mats doing exercises. I said, what are you doing? She goes, oh, I'm holding my hot yoga class. I never heard of hot yoga before, but apparently it's a thing. And she's having these women exercise in rubber sweatsuits, and she's got the thermostat cranked up to 110. And it's nice that you're working out, but ma'am, you're conducting a commercial venture in a residential apartment. These women are paying her money to come to her place and sweat out some pounds. I said, that's illegal. You can't do that. Why not? Because you're living in a residential apartment. And by the way, these people are guests and you have 12 of them. Your lease specifies no more than 3 guests at a time without proper authority from the landlord. Secondly, I don't know who these people are. And because I don't know who they are, neither does anybody else in the building, that runs security issues with me. Third, you're operating a commercial venture in a residential apartment, which is illegal. You can't do it. So I have to ask you right now to dismiss your class and never hold the class in here again. She goes, but I need this room to do my business. I do it 3 days a week. I said, no longer. She goes, in other words, you're going to wreck my business because you don't like me doing it in your apartment. I said, no, you're wrecking your business by bringing it into a residential apartment. It's not my fault. It says right in your lease, which you signed, no illegal use of apartments or grounds. And this is what you're doing is illegal. But I didn't know. Doesn't matter. Ignorance doesn't count. So guys, understand they have rights. Tenants have rights, but not to do anything they want to. If they're growing pot in their apartments, that's illegal. They can't do it. The laws are changing, I know, but right now it's still illegal. You can't do it. So any legal purpose is what they have a right to do, but they do not have rights to do anything illegal. Does anybody have any questions on this? I feel like I'm talking to like a brick wall. There's like nobody out there, nobody asking questions. Everybody's still sleepy because of the weekend? Or you just all worried about the 1.5 feet of snow coming on Wednesday and Thursday? Okay. Nobody has any questions whatsoever. We're all alive. I'm glad to hear that. Does that apply across the board? Specify across the board, Michael. What do you mean across the board? And does what specify specifically? Okay, no worries. I get the point that you're all listening very intently. Thank you. I appreciate it. I hate hot yoga. I hate anything to do with yoga. That's besides the point. The book, I think, said the 5-day grace. I'm sorry, let me just read that again. I think the book, I think, said the 5-day grace wasn't everyone. I'm not sure what that means, Michael. Guys, remember, if you're going to ask me a question in a sentence format that's complete so I can understand what you're asking and give it some context. Please don't write paragraphs and stuff like that. And I do very poorly with partial sentences as questions. Well, James. Oh boy, some of you guys really crack me up. I appreciate that. The grace period on rent payment, I think it didn't apply to everyone. Michael, I was just stating a policy of a landlord's decision to allow a grace period. There is no state requirement that must provide a grace period for tenants. We were going to talk about that more in detail, but since you brought it up, and I'm going to moderate the conversation, let's explain and talk about that. Tenants do not have a right to a grace period to come late with their rent unless the landlord gives it to them. Most landlords give tenants a 5-day grace period to be late, but they don't have to. Some tenants give 10 days, but they don't have to. It's called grace for a reason. To overlook your late payment, that's fine. However, if the landlord says there is no grace period, then you owe the rent on the day it's due, and there is no late period. But there is one extra thing about being in a late payment scenario, and that is if the landlord gives, let's say, 5 days to a tenant to be late with the rent, a senior citizen, 65 years of age or older, has an additional 5 days in which to be late. If the policy in the house is there's no grace period, seniors get an automatic 5-day grace period. In other words, senior citizens, 65 and older, get 5 days grace period to be late with the rent if no one else has anything. If anybody has 5 days, they get an extra 5. They have 7, they get an extra 5 on top of that. That's the law in New Jersey. So for grace periods, no, it's not required the landlord give you grace period. However, if he does, that's being really nice of them. but a senior gets an additional 5 days over what anybody else is allowed. So I hope I answered your question in a more substantial way. I was going to present it later, but since you brought it up, might as well talk about it now. All right, moving on. Typical lease provisions also have special New Jersey requirements in them. First of all, if you'll turn to page 198 in your 14th edition hard-covered textbook, that's this one. If you'll turn to page 198, there's the New Jersey Realtor approved form of residential lease. It's what we use in the trade, New Jersey. Become intimately familiar with this contract. Last week on Friday, we provided with the New Jersey Realtors sales contract. Here now is the lease contract, good for any residential lease in New Jersey. So first of all, and I'm going to try to find the paragraph. Okay, here on page 203 in the same textbook, on the bottom of the page, article number 39 is a declaration of licensee business relationships. So under your New Jersey requirement provision at the bullet point number 3 on the PowerPoint, the first thing says, identify business relationship firm has with either party. There in the contract is where the salesperson says, yes, the XYZ Corp and you, the agent, are working as a seller's attorney, landlord agent, landlord agent, tenant agent, or disposal agent, or transaction broker. You would specify that in the contract itself. So New Jersey has a requirement about business relationship that must be disclosed in the contract. Secondly, there's a requirement that there's an acknowledgement of the consumer information statement. That happens to be the paragraph before that. That says that the consumer got this consumer information statement prior to the broker showing property or discussing or signing things. And we talked about the process last week of that. And the third bullet point says prior to the first showing. So it must be before I show you property, you must read and understand the consumer information statement. New Jersey has additional lease contract provisions that are not specifically listed. Actually, they are in the contract. And that is item number 41. And that is smoke detectors, CO detector, and nowadays working portable fire extinguishers must be affirmed before a tenant can take possession. So when a landlord is leasing a residential property in New Jersey, they must call the local municipality and have a smoke detector, fire detector, and portable fire extinguisher inspection performed before tenants can take occupancy. And it must be the new style smoke and fire detectors. You can no longer use the 9-volt replaceable battery units. They must be the new 10-year sealed battery compartment units that are being inspected today. And besides that, one has to be on every floor, one within no further distance than 10 feet from a bedroom. There must also be working portable fire extinguishers in each unit, minimal one in the kitchen wall mounted, and it must be recently charged within the past 12 months or purchased from the past 12 months to pass inspection. The fire departments are cracking down on these requirements, guys. Many landlords don't bother getting these verifications, and bad things do happen because of that. Someone dies, someone gets smoke inhalation, someone gets burned or harmed in some way because a fire or a CO backup occurred. And in that instance, the landlord will be liable for any health problems that the tenant has acquired because of that. So understand, guys, New Jersey's very safety conscious. Must have working portable fire extinguishers in each unit. One must be wall mounted in the kitchen. They must have working CO detectors, one on every floor. They must have working smoke detectors, one on every floor, and both the CO and smoke detector must be within 10 feet of the bedroom units. That's the state of New Jersey requirement. Was there any questions about that? I see a couple folks typing, so I'm going to hang on. Do we order inspection before signing leases? Yes. Is it 10 feet for each bedroom for CO? Within 10 feet of the bedroom unit. So if you have 3 bedrooms on one floor and one is mounted within 10 feet of all 3 bedrooms, then you only need one. Or if you got them spread out, then you may have more than one. When you say there has to be fire extinguishers in each unit, do you mean with each detector or near each one? No. There must be a minimum of one portable fire extinguisher located in every rental unit, in every residential rental unit. That's what I'm talking about. Do the smoke carbon monoxide fire extinguishers apply retroactively? In other words, I'm in a unit I've rented for over 15 years. They need to be updated, or is it okay to leave things as is? The law is written that any new occupancy must meet the new standards. If I were you, I would contact the landlord and say, hey, shouldn't you be having the new units installed? Just an ask if you would. That way you'll get the latest safety equipment available to you. If they refuse to give it to you, I do not believe, unless you're living in a 3-unit or more. Is the building 3 units or more, Michael? Yes. Well, then you have the DCA inspect you every 5 years. So you must have experienced an inspection by the Department of Community Affairs. One of their requirements, supposed to be, is to make sure that they're all updated. Supposed to be. Whether they do it or not remains to be seen, but they're supposed to make sure that they're reminding landlords to update their stuff. Well, I'm sorry that they're not advising your landlord properly, but how do you know that they're not advising your landlord and your landlord's just ignoring it? Just saying. The law is written so that every new lease is required. Okay, let's move on. Good questions. Other typical lease provisions, there's a federal lead-based paint disclosure requirement for every residential lease, whether it's a house, an apartment, whatever. That means the landlord must comply with the federal requirement that they sign and initial that they know of or don't know of any lead problems in the property, or they have or do not have any reports of lead problems in the property. That must be introduced to the tenant, who must additionally sign that form, and you as the realtor, if you're involved, must give copies to everyone and keep a copy with the lease contract for no less than 6 years. So a landlord, even if he doesn't use a realtor, is required to disclose the presence of lead paint on the property, whether he knows that there's problems or not, or has reports or not pertaining to the lead paint. And the landlord is to keep that record, usually for no less than 6 years as well. And the EPA has the right at any time to inspect the owner's records. If you're the property manager working for the owner, then you're keeping the records for the owner. So you better comply with the standards of the lead-based paint disclosure. So the rule is any residential lease premises that was built before 1978 must have the lead paint disclosure form signed by buyer and seller, landlord and tenant. Also, landlords are to provide the Protect Your Family from Lead Paint booklet to the Tenant. It's an EPA publication. As a realtor, you want to make sure you give this booklet to your tenants upon looking for a place to rent. So the New Jersey requirements, once again, are fire and smoke detector, working portable fire extinguishers. Federal terms are the lead-based paint disclosure. You can go to EPA.org and find the Protect Your Family Against Lead Paint issue booklet and download it as a PDF if you'd like. There's one other New Jersey requirement, and that is that every residential lease, no matter how long it's for, must provide an attorney review clause in the lease, which states landlord or tenant has the right to review the signed contract with their attorney for a minimum of 3 business days before the contract becomes final. So if you're a tenant and you signed a lease, you have 3 days in which you can review this contract with your attorney and then decide whether you want to move in or not. If you decide no, then the landlord's required to give you your money back. If you do decide to move in, then they keep your security deposit in your first month, you move in and everything's cool. But the question is, did the landlord, if he didn't use a realtor, and if you as a tenant didn't have a realtor, did you get the attorney 3-day review period in your lease? I'm going to tell you, it's quite probable that most of you, if you didn't use a realtor, didn't get the attorney review clause. It's supposed to be in every residential lease. It's in our lease, but a lot of property owners who don't use realtors use their own leases, and they don't want tenants to know their rights, so they just don't even put in the attorney review clause. So the question is, did everybody who's renting a residential apartment, if they didn't use a realtor, get the attorney review period option in the lease? Hopefully you did, because it's required under New Jersey law. And not seeing any responses, I'm going to assume that everybody got the attorney review option. Is the lead paint booklet a separate item from the disclosure statement? Yes, it is. They are separate items. They are not the same. Frana, you're back. Thank you for coming back. How are you? Everything good? What's your question? Again, keep it short and sweet. Sentence or so. No paragraphs. Some apartment owners request for more than 2 months' rent. Is that legal? We're going to be talking about security deposit in about 3 or 4 minutes, so hang on to your question, Frana. We're going to address it. If a attorney review clause is not in the lease, does that make the lease void? No. However, if a realtor is involved, then the realtor can be held responsible for not performing their job correctly, because a realtor must ensure that these things are done. All right, not seeing any more questions. Let's move on. Security deposits. There we go. Now we'll talk about those things. So the book says no more than 1.5 months rent can be used as security deposit. So your question, can a landlord charge 2 months rent for a security deposit, is an overall resounding no. It's illegal. The state of New Jersey mandates that landlords not charge more than 1.5 times more than the total monthly lease payment. So if your lease payment is $2,000 a month, the maximum amount of security deposit your landlord can ask you to pay is $3,000, 1 month and times 1/2 again. If Here's another instance where landlords are saying first and last month and a month and a half security deposit. That's illegal as well. They're typically holding the last month as additional security deposit, and that's illegal. You can't do that. If they're not holding it for last month's security, then what the hell are they doing asking for it? Where is that money? Are they using it for their own private enjoyment? That's a good question. It's illegal to do, but people are doing it because realtors aren't involved in the transaction. Since tenants don't know their rights, they take advantage of people. Any comment or question about that security deposit issue? I think I answered the question. So no more than 1.5 times the total monthly rent is the security deposit. All right, monitoring the conversation, moving on. Now, other things about security deposits. Interesting. Number one, can't be more than 1.5 times the monthly rent in total. Number two, the landlord must hold that security deposit in a interest-bearing trust account. This trust account, as I said, must be interest-bearing. So when a tenant signs a lease, the landlord is required to notify them what bank the security deposit is going to be in. And then once a year, required to notify the tenants by a written statement, the security deposit is in this bank under this account. Here's your original balance, and here's how much interest you, Mr. Tenant, have earned to date on your security deposit. So that when you move out, if you cause no damage, the landlord will return the full security deposit to you, plus the interest that belongs to you because your security deposit earned the interest. The landlord is not entitled to your interest. The landlord is prohibited from keeping your security deposit in a non-interest bearing trust account. The state of New Jersey is very clear here. It says landlords must keep tenant security deposits in an interest-bearing account. Any questions on that part of the statement? Do they hold the interest until you move out or return the interest to you each year? No, they hold it till you move out, Michael. This is applied to landlords who live out of state, but their property is in New Jersey. It applies to all landlord properties in New Jersey, Richard. Where they live has no bearing on the laws of New Jersey. What if property is damaged, but not enough damage for the full deposit? We're going to talk about that in a minute, Nicholas. What happens when you check out? We're going to talk about that in a minute. A couple more people typing. What happens if the security is not held in an interest-bearing account? Then the landlord is in violation of his right, his rule, his obligations as a landlord. If a tenant reports them to the Better Business Bureau, they will crack down on him. What if the interest-bearing account has fees? That's the responsibility of the landlord to take care of, not the tenant. The book mentioned on page 207 that the tenant is entitled to all interest as a credit towards rent on the anniversary of the lease. If the landlord and tenant agreed to do that, they could. In other words, hey, Mr. Landlord, I gained an extra X amount of dollars towards on the interest. Can you throw it in towards rent for my next payment? I'll write you a check for the difference. If that's true, the landlord would then communicate that with the tenant and say, you have the option to do that. And that's correct. They could do that. I'm speaking in generalities here, guys. But yes, that's correct. Anybody else? Ooh. How much notice does a tenant have to give before moving? We already talked about these before, James. Depends on your estate. Is it a estate for years? Is it a periodic estate, or is it tenancy at will? That would depend on your notice period. So we got that. Can a landlord keep part of the security? Again, we're going to talk about under what conditions in just a few minutes. So I know your interest is piqued, and I will answer your questions, but I want to make sure we do it in an order that we remember the stuff. That's all. All right, so, okay. When tenant moves out, the landlord doesn't give security deposit back and also doesn't give tenant the interest earned on the account. Landlord can be sued or, okay, guys, we're going to talk about that. Again, I'll say this again. We'll talk about this in a minute. But if anybody else has questions about this, please, guys. When I say, does anybody have any questions about what we discussed, I'm talking about what we discussed, not about stuff we haven't discussed about. And believe me, we are going to cover this stuff. Trust me, we will. Was there any other questions before we move on? I see someone typing, so I'll wait. When I rented a bedroom in a family house, is the same thing? I'm sorry, Ivana, can you give me a better question about is what the same thing? Security deposit, your tenancy rights? I mean, what kind of estate interest you have? I'm not sure what you're asking. No lead paint at all can be in the rental of property. If it was built after 78, then no disclosures are required. But if it was built before 78, there's still a chance there could be lead in the property. So they must give disclosures if it was before 1978. But no, it doesn't say no lead paint can be in the property. Okay, I'm going to moderate the conversation. Apparently, we need to go a few levels deeper than the book requires you to know about. Again, guys, when we're talking about these concepts, is what you need to know to pass an exam. For all this other information, it's not required to know to pass an exam. But since you asked, and since we're obviously in a very inquisitive way this morning, let's talk about some of these things. So let's put everything on hold and talk about a couple things. So I made to make sure I'm addressing the right person. Lead paint issue. If the building was built, a residential rental building or house or whatever, is built before 1978, it must have the lead paint disclosure on every unit in the building. Does that mean there's still lead paint in the property? There could be. However, most owners of property repaint every so often and encapsulate the lead paint under existing layers of paint. And if that's the case, that paint is not really a harm to anybody. But the landlord still must give the disclosure form if it was built prior to 1978. So whether there's lead in the property or not is regardless of the fact that the landlord must sign and be honest in his disclosure of lead paint in the property if the building was built before 1978. So I wanted to address that one first. Now to the other questions about security deposits. When do I get it back? How much can a landlord take out? Let's go ahead and tackle that. Forget the order. You guys have a desire to know, so let's talk about it. Landlords, upon checking the tenant out, usually do an inspection of the property. They inspect it when they move in, they inspect it when they move out. And then they compare their inspection reports. When you checked in, this was the condition, there's your signature, and you verified that information. When you checked out, this was the recorded condition, you verified that by signing, and we compare the two. There's some differences. You put some holes in walls, you repainted the entry foyer. Those are things that the landlord are going to have to correct for the new tenant when they move in. So those are the items that the landlord can use your security deposit to repair, return to previous as was conditions, so that the next tenant moving in gets the same apartment that you got. tear items. It must be due to damages or improvements that the tenant made to the property without permission. Then and only then can the landlord use your security for repair of damages. Now, the landlord must return your security deposit and or an explanation of the expenses, and if there's any balance left, within 30 days of you checking out. So those are the additional statements and laws regarding security deposits that we all need to know about, as well as one more. The landlord is the one who decides if the tenant gets to use the security as a last month's payment. Tenants don't have a right to say, just use my security as the last month. The landlord could say no, and he's perfectly within his right to do that. Security deposit is held by the landlord to protect against loss of value because of damages by the tenant. Now, since we brought it up, and I was going to discuss this later, might as well get it all out now. Because of COVID-19, landlords were mandated by the state of New Jersey to use security deposits as monthly rent for those tenants who were infected or were affected by COVID-19. Which means landlords had to use security deposits for additional rent if the tenant was affected in some way because of COVID-19. Then the landlords were left with no security deposits for tenants living in their properties, which meant if tenants damage their properties, they have no way to repair that property except out of their own pockets, and that's not right. In fact, a group of landlords has now formed a legal class action suit against the state of New Jersey, and the lawsuit's going to be for hundreds of millions of dollars because, according to the state constitution as well as the U.S. Constitution, governmental agencies do not have the right to interfere in private contract arrangements. A lease, a residential lease, is a private contract. Because the governor stuck it, governor, I'm going to call him just Governor Knucklehead because that's what he calls everybody else in the state, unilaterally decided that landlords have to do this, and so he instituted a law. It's an unconstitutional law. So how are landlords supposed to protect against damage if they're supposed to use the security as rent and the tenant damages the property? My feeling is that this class action suit is going to be successful. The state is going to have to pony up hundreds of millions of dollars to landlords who were injured because of this, and yours and my taxes are necessarily going to jump because of this. Just saying. That's my personal take on the matter. So now that we got those things out of the way, was there any other questions about what we have talked about? I see Yvonne typing and Stacy, so I'll wait. And maybe some more, so there might be more questions. Or they're not asking questions. I'm ready for the late payment topic. I don't know what you're talking about. We already talked about if a tenant was late. So I'm not sure what other late payment topic you're talking about. Okay, was there any other questions, guys? I don't want to delay too long. In the case of eviction, we haven't even talked about eviction yet. So when we get to eviction, Stacy, bring your question up again when we get there. Again, I have it. My question was, does anybody have any additional questions on topics we've already presented? So guys, I just want to keep pace in the order in which I present stuff. It makes the most sense logically to remember That's all. Heather, you have a question, so does Farhana, so I'll wait. Can you repeat the late payment topic at a high level? At a high level? I'm sorry, Heather. No, we've talked about it already. It's like yesterday's news already. And by the way, you can always read the book. It tells you right in the book of what that is, if you're interested, which you should be doing anyway. Remember, you're supposed to be pre-reading these chapters before you come, so we don't be asking questions like all these things that obviously people didn't read the book beforehand. So guys, I don't want to delay and I don't want to insult anybody's intelligence, so I'm just going to move on. I'm sorry, but we have a lot of information to get out to you. We have 2 chapters to get through, and our current pace, we're not going to be able to get to the 2nd chapter. So we do want to move on. Please just understand, we do need to get this stuff done. All right. So we talked about the late payment about what, 15, 20 minutes ago, the landlord's discretion to offer a grace period or not, and it's up to the landlord to decide what the late payment fee is going to be. Now, legal principles of a lease. The legal principles, meaning what are the rights and situations that landlord and tenant find themselves in. Number 1, the tenant has the right to possess the lease premise, as we said before, for any legal purpose. There is an implied covenant that the tenant has the right to possess because they're the party named on the lease. And the lease, as I said, was a conveyance, a demise, a transfer of rights to a tenant. What about improvements, Tim? Can I just like put lamps and stuff in my apartment? The answer is obviously yes, but you can't modify the apartment in any manner that you didn't receive it in. But I don't like the color of the paint they gave me, so I'm going to repaint the walls. Did you ask your landlord if you can do that? No, I'm just going to repaint the walls. Well, what's going to happen when you check out? The landlord's going to see that. Besides, he's going to be inspecting your apartment every so often. We'll talk about that later. And when he sees that, he's going to say, hey, you're supposed to have, I painted those walls all white. Why'd you paint them mauve or taupe? Cranberry, salmon, I don't know. Sounds like a food platter. Why did you paint it that color? You're not supposed to be improving the property without the landlord's permission. Or I see you put up shelving. Did you ask permission to have that done? No. Well, guess what? Because you made changes to the properties without the landlord's permission, he has the right to claim those improvements as part of the real estate, unless you have written permission from the landlord to make those changes. You don't like it? Well, that's the way it is. Tenants do not have the right to unilaterally decide to improve property. I'm going to add this. I'm going to do that. I'm going to take down a wall. I'm going to open up that space. You don't have a right to do that. You have a right to live, use the property for any legal purpose. You have the right to quiet enjoyment and privacy, but that is pretty much where your rights end. You do not have a right to alter the property in any manner you see fit, unless the landlord gives you written permission to do so. So just be aware, guys, tenants, again, do not have the right to alter the property in any manner or, quote, improve it, painting, trim work, shelving units attached, altering the configuration of a wall for some manner. You don't have rights to do that. And if you did, the landlord most likely is going to charge you out of your security to return the property to the as-was condition before you rented it, so that when he rents it out to the next tenant, it's in the same condition that it was when you rented it. So once again, tenants do not have the right to improve property without written permission from the landlord. So who's that? Saminia Ferrer, you apparently have a question. Your keyboard's been open for quite some time, so we're going to defer to you. What's your question? So I'm still waiting for your question. Okay, guys, just a quick reminder. If you leave your dialog bar open, it looks like you got a question. So that's why we interrupt class for your question. Again, please be conscious of that because we don't want to waste unnecessary time. I'm sorry, Farhan, you said, is there a specific definition for some normal wear and tear as it may be different for every person? No. Normal wear and tear is how does an item wear over time? In other words, you got paint on a wall. You should reasonably expect a good 10 years of coverage on a good cover or a good gallon of paint before it starts to wear and thin. However, if I just painted all the walls and when I go to check you out, I see all these rub marks and bare spots, that's not normal wear and tear. If I just installed new carpets, they shouldn't be beat up after 1 year. They should last a good 5 to 7 years before anything happens. New hardwood floors, they can get scuffed, I can resand, but if you're crushing smokes out on your floor, that's not normal wear and tear. All right, so I think I answered your questions. I do want to make sure I cover them, but I do want to move on as well. Now, maintenance of the premises. Who's responsible to take care of the property? The landlord ultimately is responsible for the maintenance and repair of the building and to keep it in a habitable condition. It must also be in a safe condition. And believe it or not, there are definitions about safe. Federal government says rental properties are considered safe minimally if the deadbolt throw on the lock is no less than ½ inch into the jamb. In other words, the lock on the doorway to your unit, there must be a minimum of 1/2 inch throw from the deadbolt seated position in the lock as if it's an open door to where it's locked in the closed position. Must be a minimum 1/2 inch throw from the bolt. If your lock has a 1/4 inch throw, it's considered unsafe. And believe me, anybody with a credit card can get in your apartment because it's not a very good, strong latching system, a 1/4 inch. So there are required safety and habitability requirements for landlords to provide, including if a landlord provides heat in a building. Then between the dates of October 1st and May 1st every winter, the landlord is required to keep the heat at no less than 68 degrees during the day and 65 degrees at night. That's if the landlord supplies the heat. If the tenant supplies the heat, then they're paying for their own comfort level and they can keep it anything they want except below freezing. So any questions on possession, improvements, or anything I've talked about as far as maintenance goes so far? Okay, I'll hang on. A couple questions. Is the 60 during day, it's 68 during the day and 65 at night, a minimum for the built landlords? If they supply heat, yes. 68 during the day, 65 at night. I see Nicholas and Yang got questions, so we'll hang on. If tenant broke the AC, should the landlord pay to repair? No, if the tenant broke the AC, then the tenant must pay for the repair of the AC. And I don't see any more questions, so I'm gonna, oh, there is. If sewer clogs due to wipies being flushed in a plumb, okay. All right, we're starting to get off track here, guys. We're now thinking of the what ifs. Don't do that. All you have to remember is the landlord is responsible to provide heat 68 degrees during the day, 65 at night if he's responsible for supplying heat. As far as tenant-caused issues, the tenants are responsible for the cost of repairing or replacing, not the landlord. The tenants are responsible. If they cause the sewer to back up, then the tenant's got to pay. That's just common sense, I would think. All right, I'm going to moderate because I don't see any other questions, and I'll move on. The tenant must return the unit in the same condition as received. If you are a tenant in a residential building, I assume, and I hate to assume, that when you checked in, there was a condition report that you and the landlord signed about the condition of the property when you moved in. And maybe they took a bunch of pictures as well to prove the condition. And when you check out, they're going to compare your checkout notice and pictures to the check-in notice and pictures. How do they stack up? Well, there's definite damages caused over the period of the year that they were there, and that's not normal wear and tear. It's evidence in the checkout. Therefore, the tenant's responsible for the cost of repairs. The tenant is required to return the unit in the same condition that they got it. If they put up shelving, they're then required to spackle, sand, or spackle and tape, sand, and paint as required. If they don't, the landlord will charge them for those things. Apparently there's more questions, so go ahead. What's the question? Mitchell, did you have a question? And William. Can the lease be provided in Spanish, or does it need to be in English? Well, all the leases that realtors use are in English. So if the tenant wants to have a Spanish language lease, they're going to have to still sign an English lease as well as a Spanish equivalent. But there has to be a written lease in English. What happens if there's an inspection sheet to be completed and there are things that are, I'm sorry, Mitchell, I'm trying to understand your question. What happens if there is an inspection sheet to be completed and they are things, ooh, I'm sorry, Mitchell, Michelle, I'm sorry. I'm sorry, I don't understand your question. What things are missing? It should be the same form that you checked in with. It should be the same exact form. Condition report, check in. Condition report, check out. It should be the exact same report. Just one's checking in, one's checking out, and then you compare them. So I hope I answered the question. I'm not sure if that was the question you were asking, though. I'm going to assume it was since you don't respond, so let's move on. All right, now for any building that has 3 or more units in it, 3 family or more, if there's 3 residential apartments or more in a building, the Department of Community Affairs in Trenton, New Jersey, has jurisdiction on the property for inspection criteria. And every 5 years on a building that has 3 or more rental units in it, they will inspect the premises for safety and habitability conditions. If the building is good, it passed inspection, then the DCA writes up what's called the inspection card. It's colored green, so realtors call them the green cards, believe it or not. And it must be on prominent display, or at least a copy of it must be on prominent display, along with any contact information about building managers or owners, in a convenient spot where all people can see it in the building. If it doesn't pass inspection, then the landlord is required to alternatively house the tenants until the building does meet inspection criteria. So the Department of Community Affairs is very fastidious in their inspections. Excuse me. If they have determined that the building is satisfactory, they sign the green card and everybody's cool. But if not, then the landlord must house their tenants in an alternative location at the landlord's expense, make any necessary repairs or condition changes to meet the criteria of the DCA, and when they come back and inspect it and it passes, then the tenants are allowed to move back in. Also, if a tenant withholds rent because of a situation in the building, then there are certain guidelines about what's called constructive eviction process. We will address this later when we talk about evictions in whole. Right now, it's a condition in the lease, a principle in the lease that says the tenant has a right to expect a habitable and safe environment. So what is habitable besides heat, Tim? Okay, locking doors, obviously. Functioning utilities, whether the tenant or the owner pays them. No broken windows. Functioning, working heating system. Functioning, working plumbing system, including sinks, toilets, shower stalls, tubs. They must all be in working condition. Not leaking. Electricity should be working easily and not be overloaded very easily. So habitability means several things. Is it normal to live in an apartment where normal services can't be provided in a substantial way to you? No. So those normal life, the normal services that you expect to live wherever should be furnished in that rental apartment as well. But if a tenant feels that their basic services are not being met, then they have a right under what's called constructive eviction to withhold rent. But again, I'm going to talk about this a little later. Just that we have the rights as tenants to live in an atmosphere that is habitable and safe. Now, there are other legal principles in a lease. Assignment of lease. What's that? Well, I will tell you this, our New Jersey contract, and I'm going to refer to it again, specifically states in the contract that, and if I can find the paragraph, just give me a sec. Item number 11 on page 200 in your hard-covered 14th edition textbook says right here, no assignment or subletting of the property. The tenant may not assign this lease, sublet all or any part of the property, or permit any other person to use the property. But then it says, without the prior written permission of the landlord. Therefore, if a tenant wants to assign a lease to somebody else, you have to have written permission of the landlord to do it. You can't just assign it and move out. If they want to sublet an apartment, landlord has to give you written permission to sublet, or you're not allowed to sublet. The difference being is that if it's a sublease, it is a transfer of the entire leasehold estate to another. An assignment is a transfer of the entire leasehold estate to another, me being the assignor. Decide I'm going to move and it might still 6 months left on my lease. Well, I'll just get somebody who pays the rent for me to take my place for the last 6 months. So I'll tell the landlord, hey, I'm moving out. This guy's taking over. The landlord says, no, you're not. What do you mean? You don't get to assign a lease unless I agree in writing to it, and I haven't agreed to anything. Therefore, you're still responsible. But this guy's going to pay the rent for me. How do I know that? Because he's going to pay the rent. He never passed an application or a background check. He has no rights to the property just because you decide to give it to him. No. It is the landlord's permission that allows me to allow a tenant take my place where I'm the assignor and that other tenant is the assignee. And here's the other thing. Even if the landlord allowed this to happen with a written statement, what happens if the assignee doesn't pay the rent? then I, the assignor, am still on the hook for the payment. So wait a minute, I'm moving out, going to another state, and that guy doesn't pay. You're going to chase me for the payment? Yep. I'm not going to pay it. Well, then I'll ruin your credit. Well, I can't afford that. Then you got to pay the rent. But it's his problem. No, it's not his problem because you're the assignor. You're still responsible if he, the assignee, doesn't pay. And that's part of what an assignment means. I don't like that assignment business. So that's why landlords usually never allow it unless the assignee can pass a criminal background check, an employment verification, previous references checked out, passes a credit screening, and has a bank account and a job to pay the rent. They won't usually let anyone just assign a rent to somebody else. Subletting is a transfer of less than the entire leasehold estate to somebody else. In other words, I'm going to sublet the apartment to this guy. Well, this guy is going to take premises, but I am still the primary lessee, regardless of what the sublessor does. I'm always responsible for the payment. Even if the subtenant doesn't pay, I am still responsible. Therefore, it's a transfer of less than the entire estate to the tenant. I'm still totally responsible for the payment to the landlord, regardless. Was there any questions about assignments or subletting? Not seeing any. We'll move on. I'm sorry, Michelle, did I miss a question? What happens if there's an inspection sheet? Okay, yeah, we did talk about that. Okay, moving on. Destruction of the premises. Well, obviously, the tenant's not allowed to harm the property in any way. Obviously. The landlord is not to harm the property in any way. But, and this is a big if and but, what happens if the building burns down? Then the tenants have nowhere to live. That's nasty. That's a sad situation. And guess what, guys? It does happen. So liability of either party in this event of destruction of the lease premises controlled largely by the terms of the lease. So what does the lease say if the building burns down? It says landlord is not responsible for tenants' housing expenses. Then that's the answer. If the landlord in the lease said landlord will seek alternative housing for tenants and pay for that, then that's what he's going to do. But it all depends on what does the lease say. You know, a lot of people ask me, hey, what are my rights here? And the first thing I tell them is, I'm not an attorney. I can't give you legal advice. But my lease has conveyed information to me. Well, I say, well, then this. What does the lease say precisely? Well, I never really read it. So that's where you should go first, is the lease, because that's where it's explained. So understand, guys, tenants' rights are dependent on what the lease says if the property is destroyed. Yang Zhang, you have a question. What is that? What if tenant is the cause of the fire? Then they may have criminal charges initiated against them if it was intentional, obviously. But again, that's accident. Happens. Well, the landlord's not responsible for any tenant belongings. And if the tenant caused the problem, the tenant's probably on their own. Depends on what the lease says. I can't infer any other rights or obligation. It's what does the lease say? I know it's 10:30, Alia, and we are going to take a break. I just want to answer a question first. So again, now it is 10:30. It's time for our first coffee break of the day. I'm going to leave the conversation pit open. You can talk in amongst yourselves, do whatever you want. I will return at 11 o'clock. We'll pick up the topic, termination of lease, and move on from there. So I'll see you at 11. All right, welcome back, everybody. It is 11 o'clock, and it's time to start again. Another hour, we will be breaking for lunch, but right now, we got to finish up more information in this chapter. So we're talking about legal principles of leases. We just finished the structure of property, and now we're going to talk about termination of those leases. Actually, we already presented this information before, but this is a recap. Terminating leases. Well, if a tenant violates the terms and conditions of the lease, then you can terminate the lease by having them evicted. Excuse me, if they stop paying rent, you can evict them. So there's many different ways you can, by court process, terminate a lease, usually through default of payment or default of any of the terms and conditions of the lease itself. It's possible that both parties could agree just to cancel the lease so the tenant can get out without having anything follow them regarding debt or issues regarding non-payment. So both parties could talk about it, and usually the best way is to talk to your landlord about a problem, and maybe he'll work things out with you and mutually decide to terminate the lease. That would be great. But if a tenant takes possession of a unit, then termination usually occurs according to the following, which we did present already. Estate for years, no notice required. It terminates at the last day of the lease schedule. Periodic tenancy, the period that repeats is the notice period not to exceed 90 days. Just tenant at will, mandatory 90-day notice to terminate. Death terminates a lease if a survivor notifies the landlord within 90 days of the lease. Yes, I did just say that. So if the tenant dies under an estate for years or a periodic estate, it ends automatically under a periodic estate if it's month to month after the next month. Or it could still go on. So one of the relatives or someone must notify the landlord of the death of the tenant, so the landlord stops assuming that the tenant is merely on vacation or something. So selling the property does not terminate a lease. Some people think that if the building is sold, then the new owner can kick them out. That is an untruth. If you have a valid lease on the property, the buyer must honor the existing lease. If you don't have a lease on the property, but just under a verbal arrangement with the owner to be there, then the landlord could use the clause of, you're a periodic estate, therefore it's 30-day notice, you must leave. That doesn't give you a lot of time to go out and find a new place to live now, does it? But that, in fact, is what can happen if you don't have a valid written lease. So as always, I always warn folks, make sure you get a lease, a written lease agreement, no matter how long the terms are, because then you know exactly what your rights are. And when the building is sold, the new owner must honor the existing lease until it terminates. Question, let's see. A couple things I missed. Let me just go back for a second here. Keep the security deposit and document everything. Oh, I think you guys might be talking about something else. That only implies if the owner doesn't live. I'm sorry. Am I talking about the same thing that you guys are talking about? I don't think so. Maybe that was from our break or something. You guys were talking about stuff. What if there is a previously identified occupant of the unit? Do they have the right to? Can you explain what you mean, Pamela? What do you mean previously identified occupant? In other words, they have an existing lease. They occupy a unit. Then they stay until the lease expires, because the landlord, whoever the new landlord is moving in, can't terminate their lease. They must honor it. Okay, you guys were chatting over it. Okay, good, that's fine. If and they are on the lease. If and they are. That sounds like Appalachian talk. if and they are on the lease. I'm sorry. What if there is a previously identified occupant of the unit? Do they have the right to stay? If they're on the lease with a deceased tenant, if they're a named party to the lease, then the lease continues under their name, yes. So, but they have to be named as a competent party to the lease, yes. I think I answered the question. Didn't see any more, so, oh, there is. Okay, so I'll hang on. Is there another question? I don't want to wait too long. What about wife of deceased who is not named on the lease? If they're married by rights of estate by the entirety, because she's the spouse, she is the same person. So no, you can't kick her out. In the state of New Jersey, anyway. All right, I think I answered the questions. Let's move on. All right. Other legal principles of lease termination. We just went through this stuff, how to do it properly. So let's keep moving. Truth in renting and disclosures. What is that? Truth in renting. Never heard of it. Well, unfortunately, you should have. Truth in renting requirement applies to residential property, including mobile homes, but not commercial real estate. It's a booklet that you can download on the top of page 210 in your hardcover 14th edition textbook. Gives web addresses to the Truth in Renting booklet in English and a web address for a document that's in Spanish. Landlords are supposed to give tenants the Truth in Renting booklet prior to them moving in. There are exemptions under the law if the landlord is not required to distribute the statement or for transient tenants with terms of less than 1 month. But under the state of New Jersey law, every landlord is to supply to every potential tenant the Truth in Renting booklet. I'm going to tell you right now, they don't do it. Why not? Because the Truth in Renting booklet tells tenants what their rights are. So they don't give the tenants the booklet. Even though they're required by law, they don't do it. And no one's cracking down on this. Realtors, if I'm involved in a residential rental transaction, I must give a copy of this booklet, the link to the PDF, so that any tenant looking to rent an apartment through me has this booklet and is informed of their rights before they go out and even start looking at properties. So realtors are required to furnish this booklet or the link to the website to any potential tenant they're working with. Landlords are to supply it with any tenant wishing to rent properties from them, but they don't. Now, we can always complain, oh, that's nasty of them. Someone should do something, but you know what? The more we make noise about it, the less they do. So understand, guys, as a licensee, you're held to a higher level here of authority. The Real Estate Commission requires that New Jersey licensees, when working with residential tenants, be provided that booklet link so they know what their rights are, so that things like first and last and security charges are not imposed on them. So that when they have a written lease, it must be clear and concise in the terms, the amount of payment, how it must be paid, et cetera, et cetera. So that when people take possession, they know what their rights are to maintain possession of the property. They can't just be kicked out. Now, I've heard a lot of jibber jabber in the past several months about illegal aliens and their rights to possess rental property. Now, I'm not a civil rights attorney, neither am I an attorney in any way. I'm just a simple country boy trying to understand things in a big city, where I would infer that if I take possession of someone else's property, I would have responsibility to make sure that I don't harm that property in some way. That the landlord has some responsibility to furnish me with habitable and safe environments. That if my rent is due and payable, then I am obliged to pay that rent when it is due and payable. That if I have a problem, I should be able to contact my landlord and say, hey, can you please take care of an issue? I also believe that my property should be safeguarded against other people's invasion of my privacy. The landlord should not have the right just to walk in at any time he wants. He doesn't. But I also understand that there's a lot of things about the law I don't know. And as a tenant who's a simple country boy, I need to be informed of what those rights are. So the Truth in Renting booklet is required to be conveyed to me, the simple country boy, so I understand things like, if I'm in the armed forces and I'm called to active duty service, what happens to my apartment? Is it given away to the next guy? What happens to my stuff? Or my husband died, do I have a right to stay? Or I'm a victim of domestic violence. What are my rights as far as tenancy goes, even if I'm not named on the lease? The Truth in Renting Act booklet covers all these things, including the sale of the building. What happens? Who has rights? Who doesn't? What recourse I have as a tenant, the landlord doesn't provide certain basic services that they said they were going to. The Truth in Renting booklet covers these ideas, these rights and obligations of parties. And that is why realtors are required to give this booklet to potential tenants when working with them. We should also make sure that the landlord gets a copy so they have something that we can say we did deliver a copy of this document to the landlord. Then they have no excuse as to why they didn't pass it out. So guys, remember, we are held to a higher authority because of our licensing status, and we must do this so that tenants know their rights and obligations under a lease. Landlord should provide a link and or printed copy of this document by law, but they don't. It's just a major plain fact. They don't do it. Disclosures include things like landlord must make, or the property manager, whoever's doing the property, must make sure that tenants know who to contact if there's an issue, who the managing entity is, what's their general contact information, is there an emergency line number, and that information must also be filed with your local municipal government. Landlords have a right to access federal crime insurance if they are located in certain high crime districts, and that's provided by the Department of Housing and Urban Development. So if you're operating property in a very high risk crime area, you could apply to the Department of Housing and Urban Development for federal crime insurance should something happen to your property as a result of criminal activity. So before I move on and start talking about Americans with disabilities, was there any follow-up questions to these discussions that we're having right now? Excuse me. Looks like we lost about 10 people for some reason. I don't understand why, but we did. Matilda has a question. I'll wait. Do all renters get a copy of Truth in Renting or based on how long rental? Matilda, the book says all tenants are to be given a copy of the booklet. Doesn't matter if it's a day or 100 years. all renters. Could you please go back to the last slide for a minute? All right. That was the last slide. And now that's the current slide. Anybody else with a question? And remember, all this information on the PowerPoints, guys, is taken directly from your book. It's nothing new. It's just supplemental presentation material, that's all. And just reminder, no recording of anything. So I'm going to say. So, was there any other questions? You mentioned some kind of exception for transient tenants under a month. What was that regarding again? Again, about the giving of the truth in renting booklet. That's what it was about. Okay, still another question coming? Okay, good. We're good? Okay, let's move on. Now, the Americans with Disabilities Act. Guys, we live in a world where everybody is supposed to get a fair shake at something. And they should. The problem is, apartments are being built that are not fair to everyone. People with disabilities cannot use the same apartment that you use because it needs to be specially adapted for their needs. Now, in 1990, the U.S. created the Americans with Disabilities Act. It went into effect in 1992, requiring, and here's the basis of the argument, all government buildings and facilities must be handicapped accessible, as well as any public working areas like office buildings, public accommodations, entertainment venues, theaters, restaurants, whatever. So that when people who have handicaps go to these things, they can access the building and get in and see this thing or work there or do whatever. But it never referenced private property owners. In fact, private property owners are exempt from the Americans with Disabilities Act. If you're operating an apartment building, you are not required to make it accessible for people with handicaps. It is, however, a good practice for a landlord to make the building accessible for handicapped individuals, but not required. So what happens when a tenant shows up and says, I'd like to rent an apartment, but they're handicapped? What do I do? Let them? The answer is yes, because you're not allowed to discriminate. Last Tuesday, we went over the laws against discrimination, the federal fair housing laws, New Jersey law against discrimination. And one of the things in 1988 that was added to the federal amendment was physical handicaps. Therefore, if a tenant wants to rent an apartment from you, the landlord, they have every right that anybody else does to rent that apartment. But what about modifying the apartment for their needs, Tim? It's going to cost me a lot of money as a landlord. And the answer is, no, it won't. It doesn't cost you a penny. How are they going to live there? Well, that's very easy. The Americans with Disabilities Act says that if a residential tenant finds a place to live and needs adjustments for their lifestyle, that the federal government will offer them grant money to hire contractors to come in and make the apartment handicapped accessible. But the landlord says no improvements. He's not allowed to do that. Well, under the federal law, a person with a handicap has the right to modify a situation for themselves so they can live a better quality of life. So this actually happened to me back in I'm going to say the date, in fact, 1995 was like October something. I remember that. And back then in the 90s, we were operating properties with a normal 20% vacancy rate. That was what it was back in the day. Today, vacancy rates are like 1%. It's crazy. But anyway, I had a couple of vacancies. So I put an ad in the Star Ledger. First floor, 2-bedroom, 1-bathroom apartment available immediately, and the price was, I think, $12.50 a month. So I put in the newspaper, didn't get a lot of responses until one day I got a response from a woman who said, I'd like to come and see the apartment. I said, absolutely. I'll be here. At what time would you like to come by? And she told me, and we made arrangements. So I got the apartment a little early, make sure it looked good, it was cleaned out, right? And then a blue van pulls up to the front of the building and nobody gets out of the driver's door. I'm like, what's going on? So I go outside and here's the side of the gate, the van opens up and the gate comes down. And a person rolls out in a wheelchair and goes down to the ground. It folds itself back and plugs the doors, and she's here. She's a tenant looking for the apartment. And I said, not to be silly or ignorant, but you're in a wheelchair. How are you going to use the apartment? She goes, that's not a problem. Can I just see the apartment to make a decision whether it's going to be adequate for my needs? Okay. So I pushed her wheelchair into the apartment. We looked around. I'll take it, she says. I said, but how are you going to use the apartment? She goes, that's none of your concern. Do I fill out an application with you? Or is there someone else I should do this with? I said, no, I'll do everything. I'll supply you with a copy of the lease and offer you an application form and a request that we check your credit and permission slip to sign that. And she goes, okay. And she did all the paperwork, read over the lease, said I'm in agreement with the lease. So, and the next day I called her up. I said, your credit is immaculate. I mean, you make good coin. And she was a graphic designer. I said, are you sure you want to take possession? She says, absolutely. It's a great location. I don't work very far from there, so it works perfectly for me. I said, okay. So as she was moving in, I asked her this silly question. I said, how are you going to get to use the apartment? It's not going to be available for you. She goes, no problem. What the Americans with Disability Act does is provide this tenant grant money that all they have to do is call a special number and all of a sudden crews show up. So she goes, I'm going to call them today. And she goes, within the week, they'll be here. She called them that day. 2 days later, 2 vans pulled up. 4 guys got out. And by the end of that day, the apartment was modified. They had put grab assist rails in the bathroom next to the john and in the shower stall. They put them in the hallway in the bedroom next to the bed area. They lowered the countertops on the sinks and the workstations by 1.5 inches to 2 inches and then left. I was like, this is amazing. They came in here and modified. Now she can use everything that's available for her at no cost to the landlord, zero. The landlord found out about this. He came storming. He goes, nobody's allowed to modify. I said, excuse me. But under the Americans with Disabilities Act, tenants do have the right. And I had to read him the Riot Act so he didn't go off the handle. He says, is this true? I said, you can check with your attorneys. But as far as being a realtor, this is one of the things I'm taught is that we have to accommodate these folks. So he checks with his attorney, comes back, he goes, all right, but don't let it happen again. I said, well, whether it happens again is irrelevant because tenants have rights to do that. But I don't like it. I said, that's unfortunate, but this is the rights that people have. So what are we going to do? How long is she here for? She's here for 2 years. All right, but when she moves out, I want this place as it was before they moved in. That's the plan, and she will access the grant money to do that when she moves out. Now, 2 years later, she called me and said, I'm getting ready to move out. Did you want me to call the ADA and have them come in and fix the place back to its original condition? I said, wait a minute. I had just come from a seminar where we were talking about target marketing. I said, we got a couple weeks left. So how about if you just give me a day or two to find out what kind of sampling of population I can garner to see if anybody's interested in the apartment as it is. So I made up a flyer. This is in the 90s, before computers, guys. I made up a flyer and I went down to St. Joe's Hospital. The apartment was in Haledon. St. Joe's was only about 1.5 miles, 2 miles away. And I went to the pediatrics ward and the orthopedics ward. And I asked the head nurses in both if I could put a notice on their bulletin boards. They said, yes. Would you let us review it? So I gave it to them. And one nurse looked at me dead in the eye and she goes, honey, do you know what you're getting into? I said, no, but I have an apartment and maybe somebody has a need. She goes, good luck. I said, okay. Now that was on a Saturday morning. Monday, I checked my voicemail and there was 40 application people responding to the lead who wanted to apply for the apartment. 40. I took the first two, called them. The first person didn't answer. The second guy picks up the phone. I said, "Hi, my name's Tim Jensen. I represent the party in Haledon, and I do have that apartment available, and it's on a first come, first serve." He goes, "I'll go over this afternoon. What time are you going to be there?" Guy showed up. "I'll take it." I said, "Well, I could do your background." I did my background check. This guy also has a good job, gets paid well. He took possession when she moved out, didn't have to access any money, and paid top dollar for the unit. Now, I lost that contract. The building owner and I were good friends, not great friends, but good acquaintances. And as a business decision, he says, "I'm going to give it to my nephew to operate and everything like that." I said, no problem. Now, I saw the owner probably about 6 years ago at a conference down in Eatontown. He goes, "Tim, how you doing?" We talked. He said, "I got to tell you something." I go, "What?" He goes, "Remember that handicapped apartment?" I said, "How can I forget? I remember that as clear as it was yesterday." He tells me this. He goes, "That's the best decision you ever did for me." I said, "What do you mean? I thought you didn't like that idea." He goes, "I have not lost 1 week's rent in 20 years because of the demand that is out in the marketplace for a handicapped accessible apartment. It is unreal," he said. "I never lost more than a week's rent." Well, here's the thing, guys. There is a huge demand for a handicapped accessible apartment, but there's very few handicapped accessible apartments. And this guy had the reaction that I don't want it in my apartment until he realized the people who were occupying these units had jobs and paid good money for the rent and never lost more than a week's income on that apartment in 20 years. So understand, guys, if you get involved in something like this, understand there's a huge need, but there's very few items out there they can choose from. So the ADA says to tenants, contact us, we'll supply the money to hire contractors to fix the apartment for your needs and then put it back in the as-was condition. Landlords cannot access these funds to change apartments for themselves unless they're physically handicapped themselves. It's for their own use, but they can't do it for the building. Each tenant would have to apply for the use. However, I have counseled owners of buildings that when they're planning capital improvement projects, one of the things they may want to do is make the building more friendly to physically handicapped individuals by making larger doorways, a grab assist, bar every on any public accommodation restroom, ramps coming in the front door or out the back door, just so people can get in and out of the building and visit people. No, you don't have to put in elevators to accommodate their needs or anything like that. But again, the ADA will supply each individual tenant's needs as required. And it's useful for the landlord to consult an architect or builder versed in ADA compliance so that if they are undertaking a remodel or renovation, that they can make the building more friendly to these folks. Was there any questions on the ADA, Americans with Disabilities Act compliance? Wow, there's the paragraph I was dreading. Okay, hang on. There's a couple things here I missed. Tim, if a tenant gets into a car accident and becomes disabled, is the landlord responsible for making? No. The tenant is responsible to contact the ADA for any modifications, not the landlord. Just to confirm as what you were saying, so if a person with a disability wants to rent an apartment in a private building, can they still request a federal assistance for improvements, or does that landlord has to comply? No. The landlord doesn't have to do a thing. It's completely up to the tenant to apply for any funds to modify the apartment for their needs. It's not based on what the landlord wants, it's what the tenant wants. And the landlord can't prevent the tenant from modifying the apartment. So the landlord doesn't have to comply. He just so has to let the person do it through the ADA. Was there another question before I moved on? Asia. I'm sorry, guys. Do you know that your keyboard's open, or you're asking questions, or just forgot your keyboards were open? Sammy and Asia. I'm going to assume that you don't have questions, and I will be moving on. Sammy, can the landlord advertise that the apartment can be modified? No, tenants already know that if they are handicapped. They already know they have the right. However, if the apartment is handicap accessible, then you would want to advertise that, yes. That's it. Okay, I'm going to move on. I thought there was other questions coming, but okay. Rental referral services. What's that? There are companies out there, guys, on the interweb that advertise apartments for rent. Now, under New Jersey law, rental referral services who advertise apartments for rent have certain guidelines. Number one, they must specify what services they provide. If they charge fees of $25 or more, then they must operate escrow accounts. And everything they do must be done via contractual agreements. If the rental referral company is advertising a specific property, then they must check on that property every day for availability. If they're giving nebulous ads, like we have several apartments available throughout Union County, they don't have to check on availability every day. They have to check availability of those units every 3 days. So again, if they charge fees of $25 or more, they have to operate escrow accounts. They must do everything via contract. They must check on availability of any advertised apartment, and if not advertised specific apartments, must check every 3 days on those units. Apparently there's some questions, so we'll open it up. What was your no? Apparently now there's no questions. You guys are teasing me. Can the landlord? Okay. Apparently there's no questions, so let's move on. Rent control. Excuse me. So here's the thing, and I'm going to open it up for discussion real quick. In New Jersey, how much can a landlord charge a rent increase for a tenant? Anybody? Anybody know? %5. 2%, 10%, 5%. No more than 10%. Rent control or regular? That's the question. Good for you. Who is that? Michelle? Just going to look. Rent control or regular? There you go. Yes, that was Michael Bloom. Thank you, Michael. So here's the answer. Guys, thanks. I appreciate the input. We're getting lots of variance here. So here's the thing. Is it a rent control unit or is it a regular unit? And there's a big difference. Because number one, if it is a rent control unit, first of all, understand in New Jersey, I don't care about any other state, I'm only talking about New Jersey, all buildings that are under rent control are governed by each municipality they're in. So if you have one in West New York, then there's a rent control board in West New York specifically for rent control properties in West New York. So each municipality operates their own rent control boards. Now, not every community has properties that are on rent control. In fact, there's not a lot in New Jersey under rent control, but those that are, it's municipally operated, governed. They may be privately owned, but they're governed by each municipal body. So typically, if a rent control building has a need to raise its rents, Normally, the tenants get together and petition the rent control board to say, no increases. We live on fixed salaries. Rent control is for low and moderate income family situations, not for wealthy individuals to take advantage of a discounted rent. So these are people that have needs. So they're going to get together and petition the local rent control board for 0 increases, while the owners of those buildings get together and petition the rent control board to give them 10, 20% increases because the cost of goods and services go up, taxes go up, insurance go up, et cetera, et cetera. The rent control board is independent of these groups and decides on its own what the rent increases will be on those properties governed by the rent control division. And typically, I'm saying typically, on a 1-year renewal, they will allow a rent increase of somewhere around 2 to 3%. On a multi-year lease, they will allow anywhere from 3 to 5% rent increases. But that's about it. So under rent control, the municipality decides how much rent can go up. In the free market, I'm going to say something that not a lot of people are going to like, but it's the fact. It's whatever the market bears could be the increase. And I'm being very serious. Now, if you have been a renter for a while, you've noticed that rental contract prices have escalated and are still going up, and they're still going up. I mean, holy cow, how high can it go? Remember the guy running for president about, was it 12 years ago, or even just 4 years ago? The rent's too damn high. Remember that guy from New York? He was right. Rent is high, but it's only because the market is willing to pay that amount. I was renting 2-bedroom apartments in Haledon for $12.50 a month 20 years ago. Those same apartments, $17.50, $19.50. In Guttenberg, there's a building called the Galaxy? 2-bedroom apartment, $7,000 a month for the base rent. You want to park your car there? That's an extra couple $100. You want to use facilities? It's another couple $100, and all of a sudden, your $7,000 a month rent went to $8,000 or $9,000 a month rent. Wow. Rental increases for properties have skyrocketed. People in New Jersey, when they sell single-family homes, are moving out of state. That's a fact. 2 out of 3 home sales in New Jersey result in people leaving the state. Who's buying their houses? New Yorkers, number 1. Number 2, investors. Why investors? Because they're buying single family homes to turn around and rent out because they can get a huge amount of rent for a single family home and people will pay it. Holy cow. 20 years ago, if I could rent out my property, I might have gotten maybe $2,500 or $3,000 a month. Today, more like $6,000 a month from my private single family home I could get on the open market right now without a heartbeat. And people will be willing to pay it. The price of increase in the rental markets has skyrocketed because of the basic problem of supply and demand. There is a huge demand on private property to rent, but there's a very small supply to offer. Those that are available, whoever has the most amount of money usually gets them. If you've been in the market for an affordable place to live, to rent, and you realize there's not a lot to choose from, and those that are to choose from that it's affordable are in lousy locations, you understand that rent prices have skyrocketed, and they have. So understand, guys, under rent control, the municipality decides what rent increases can occur. In the free market, it's whatever the market bears, and right now it bears quite a bit. Anybody have any comment or question about what I'm just talking about here? What is the cause? What is causing the huge lack of availability? Excuse me. The demand. The demand right now in I'm only going to speak for my area, Michael, and that's northeastern New Jersey, Bergen County, Passaic County, Hudson County. The people coming from New York are knocking down doors to buy a house. And I'm not being silly here. Actually, I live in Oakland, New Jersey. It's in Bergen County. Everybody in my town has gotten at least one or two, if not more, letters delivered in the mail to each homeowner saying, if you're thinking of selling, please call me. I'm working with a real estate broker. We can't find a house to buy, and I need a house to live in your area. Please let me know if you're thinking of selling. Because they're desperate to get out of Manhattan because the situation is developing there. Guys, I'm telling you, there's a huge demand on housing in New Jersey. Still, even when people are vacating the state, there's still a huge demand of people wanting to live here. So understand, the demand is not going to go away anytime soon. And the supply, unless it increases, is still going to demand high value. People renting or selling property are realizing prices they haven't realized in at least 12 to 15 years when the market was at its peak before the crash in 2008. It is quite amazing what's going on. So it is all about supply and demand. Does the Rent Control Board also regulate initial rent charges? You will be the tenant in the, yes, in a rent control property, they determine what the rent will be, correct. So is the exodus from New York COVID related or just due to high rents in that area? Both, but more COVID related because of not just the shutdowns of businesses and stuff, but the social unrest that's occurring too. People don't want to live in Manhattan anymore because of that. My recent 3 offers to buy a house were outbid by others offering all cash. Crazy market. Yes, it is. So if anybody's thinking of selling, right now would be a good time to sell because it's a huge demand market right now and very little supply to offer. All right, so we covered rent control. Let me moderate the conversation and we're going to keep going because we only got about 15 minutes, 20 minutes left before we have to take a break. Now, eviction. I told you we're going to talk about this later, and now it's later. And first, let's talk about constructive eviction, where a tenant has the right to remove themselves from a bad situation. So under constructive eviction, what it means is where the landlord fails to provide, as it says, basic services or required services as part of the contract. If they're not giving the services that they promise or need to give a basic service, then a tenant has a beef with them. Mr. Landlord, there's no heat in the building. When are you going to fix it? Yeah, I'm going to get around to it. And then you never hear back from them again. But it's getting cold outside. I have to wear a jacket and maybe a couple extra blankets at night. It's not a convenient thing. In fact, it's impinging on my ability to live comfortably. When will you be fixing the problem? As soon as I can, don't worry about it. And then you don't hear from them again. This is a situation that too many residents find themselves in, usually about this time of year, when the heat starts to be needed and it's not being provided. Well, in that case, and I'm just using one example, maybe it's frozen water pipes or pests or lead paint or some sort of toxin in the property. The landlord is supposed to address these things on a timely basis, but they don't because they cost money to fix. So they don't even address it. In this case, a tenant who was adversely affected by this has a right under constructive eviction to do the following. Number one, they can withhold rent, but there's a process under which the tenant must do it. Under constructive eviction, in New Jersey at least, the process is if a tenant feels that they're not getting the basic services required and they tried reaching the landlord and to no avail to fix the problem, they should go to their tenant court in the county where the property is located, talk to the prosecutor's office and explain to them the situation. The prosecutor's office is going to help them write a letter explaining the problem to the landlord and then allowing the landlord a reasonable time in which to fix the problem. Now, in the process, the tenant posts his rent with the tenant court in their escrow account, which is held. It's not paid to the landlord, and because you're not paying, the landlord can't evict you because you're performing a legal service against them at the time, and the tenant courts will back up the tenant. So now that the tenant court's holding the deposit and they delivered the letter to the landlord is to take action and fix the problem. If they do not fix the problem in the, quote, reasonable time they were given, then they must explain to the court why the problem hasn't gone away and offer a time frame of when it will be. But if they don't even bother to contact the courts, then the tenant has the right, and the tenant court will back them up, to remove themselves, their family, all their possessions from that occupancy and find an alternative place to live, and the tenant courts will refund that month's payment to them after the landlord has failed to respond. However, the tenant court could also do the following, and I've seen them do this. Mr. Landlord, you are now under court order to fix the property. If you do not, then the court will take action to fix the property, at which time you will be billed for the repairs. And as a penalty, what I've seen tenant courts do, you must give all tenants, especially the affected ones, a minimum of 3 months free rent as a penalty. Once a landlord finds out that that's a possibility, those repairs are made. It's quite amazing. And I've actually seen courts award tenants up to 3 to 6 months rent-free living because the landlord didn't do what was required. So guys, I'm going to tell you right now, if a tenant feels that they've been dissed by their landlord and they can prove it, if they go to tenant court, they're going to help them get the problem solved, or at least maybe negotiate a free rent for a period of time because of the damage the landlord has caused. So just again, a constructive eviction is where the tenant, because the landlord hasn't provided basic services, can vacate, move out, and stop paying rent, but there is a process, and the tenant courts will assist you on how to do this. Was there any questions or comments about constructive eviction? This is going on with my dad's apartment. Oh, God. His landlord is absentee, lives in Florida, and the apartment is mold mildew. Ugh. Floors buckling and mice. Oh, boy. I had to call the city, and they cited him and made him make the repair. Good. Good. I'm glad to hear something's actually being done. Yeah, the health department is another place you can go to make a complaint, and they'll require the landlord make the repairs. Anybody else with a question or comment before we move on? I'm so sorry to hear that, Natasha. I hope everything works out for him. But okay, hang on, Michael. Where or what is a tenant court? Every county has a court specifically for landlord-tenant relations. And it's in the directory in your county courthouse directory. So if you can, let me see if I can do it from here. Hey Siri, can you tell me the Bergen County courthouse number for tenant court? 201-221-0700 is the Bergen County courthouse system, and you can ask at the switchboard to switch you over, and they will. So there is one in every county in New Jersey. It's working out. He's making the repairs, but he had to be made to make the oh, slumlord. What a nasty man. Sorry. All right, guys. Anybody else with a question? Manuel, you have a question. I'll wait. No? No question? All right. So we talked about, oh, there is. Okay. So I'm going to moderate anyway. I'm just going to take that one question, Manuel. I know a landlord that has a tenant that hasn't paid rent in almost a year with a different false issue and every time with a different, okay. Now we're going to talk about this case, Manuel. The suit for possession or actual eviction of a tenant. But before I introduce the topic, in New Jersey, our governor, once again, has created a new law as of, I think it was April. No tenant evictions. What? No tenant evictions during the COVID-19 crisis. Now, I don't know if it's on this. Hang on a second while I just look up something. No, it's not. Okay. It's on another page, and I don't have it available. But there was a New Jersey court update on July 15th of this year that I read. It said 17,200 tenant evictions have been filed with the state of New Jersey through the various tenant courts throughout the counties. 17,200 due to non-payment. And another 12,800 tenant evictions have been filed, but no action has been taken. Therefore, the state of New Jersey put a moratorium on tenant evictions as of July 15th due to non-payment, and will end when the crisis is over. Well, that was supposed to be a matter of a month or two. Then it turned into October. Then it was the end of the year. We don't see any end in sight. So landlords now, besides being forced to use security deposits as tenant rent, can't evict tenants for non-payment. The courts have moratorium on all evictions due to non-payment of rent right now, which is a crime because there are people who, unaffected by COVID, are using this as a way to just not pay rent. Landlords don't have a say in the matter because of the executive order of the governor. I don't want to talk about my opinions on this. Obviously, I have many, but again, it would be wrong of me to interject that into a classroom. But in the case where a tenant, and we're talking about pre and post-COVID, either breaches the lease by non-payment or the terms and conditions of the lease, then the landlord has a right to evict them. Typically, in courts in New Jersey, they want to see a minimum of 3 months of non-payment before the tenant court hears the eviction charge. So a landlord who's got 3 months of non-payment will file a request for a hearing in the tenant courts in the county where they're located. They will show up and complain to the judge that the tenants aren't paying rent and that he should have the right to dispossess them to regain control of the apartment and evict the people from the building. The tenant court is going to ask the tenant for their response. And tenant seems to know what the rules are because typically they say things like, well, Your Honor, I lost my job because of COVID or some other issue. And my elderly grandmother in a wheelchair will not be able to live if we have to be forced out. And besides, my wife just had a baby. The thing is, when tenant courts hear an elderly person, infant, or a handicapped person is in that family, they immediately default and say this to the landlord. Because of the extreme issue with the grandmother, the infant, the handicapped, we must allow that tenant an additional 3 months before we hear the case again to find another place to live or get a job to repay you the lease. Now you're 6 months into no payment when you get back to tenant court. And then the judge says, okay, they're not making restitution, so I'm going to order dispossess action. But, Mr. Landlord, you can't evict them. You have to go through the sheriff's department who will evict them. So then after you get your writ of execution proving your right to dispossess, you go over to the sheriff's department, show them the writ, schedule a tenant eviction. They will decide when they will become available. It could be a month, it could be 2 or 3 months. Thinking that more like 3 months is the norm. Now it'll be 9 months before the sheriff's department shows up at the apartment building to evict the tenants. And when they show up, the landlord has to pay their fee at that moment or else they'll turn around and go home. So you got to pay the sheriff's department when they show up, and then the big burly guys from the sheriff's department are going to take the individuals out personally and put them on the corner outside the building, on the curb. This is one of the reasons why I no longer do residential property management. I don't want to be responsible for putting grandma or babies out on a corner in this weather. It's not within me to do that. However, that's the law. So they'll march those people out of the building and then tell the landlord, change the lock and lock the apartment. Because you're responsible as a landlord to store their furniture until they can have a reasonable time to come back and get it, not to exceed 1 month. So now I got to lock the apartment up, store their furniture for another month of non-payment. But if they come back to redeem their stuff, then the month's payment is obviously what we charge them for the rental. At least you got 1 month back. But if they don't, then I can throw all that stuff in a dumpster and then rent the apartment after that. So you can see where the landlord gets screwed in a tenant eviction. In New Jersey, tenant courts are known to be very pro-tenant and very anti-landlord, just so you know. Now, if you've ever experienced tenant court, it's not a very fun place to be. I'd rather not have to go to tenant court ever again in my life. But the fact is that tenant courts are there to serve a judicial purpose, to protect the rights of landlords and tenants, and to make sure no one gets screwed because of a miscarriage of justice that the courts can overcome. So there is a process, a legal process that landlords must follow in order to evict tenants. Reasons for eviction are listed on page 213 in your hardcover book. But I'm not going to go list every one of them. You can read. Usually it's because of non-payment. The second reason is because they don't abide by the rules and regulations. They're in default of the lease. So, questions from anybody? Okay, I don't see. Oh, can you go after them for the amount due? Yes, you can, Frank. Good luck getting it back, but you can go after them. Sometimes landlords just have to say, it's a loss, next. Chalk it up to a bad experience and move on. Is it okay to rent a room in the main floor what? Is okay to rent a room in the main floor family house with this? You got me at that one, Yvonne. Can you try to retype that in a way I may be able to understand what you're asking? In the scenario you provided, do the belongings stay in the unit? Yes. During last month, yes. Or can you rent out? No, you can't. You have to leave that in there, change the locks so they can't come back and grab it without you knowing, and then charge them a storage fee. Can landlord use their personal property to compensate for his? Yeah, for Hannah, if they don't come back and redeem their furniture from the landlord can throw everything out, or if there's anything of value in there, he can keep it and then sell it or give it away, do whatever he wants to. What are the penalties for tenants not paying rents and get evicted? Are there any public records or evictions? Well, yeah, credit scores can be affected. If the landlord reports to a credit bureau, he's going to say this tenant had charge-offs of X amount of months rent, and that will be listed as a very negative thing on their credit report. Can the tenant be sued? Yeah, in small claims court for the damages or the loss of income. Absolutely. But good luck. I'm saying this for a reason, guys. I'm just going to moderate here for real quick. Guys, just because you go to court and win a decision doesn't mean you're going to get paid. I'm going to tell you that right now. I've had court cases against tenants or other clients because of non-payment, won the court cases, but never got a penny from them. And what am I going to do? I have to physically chase them? I can't because I'm stalking and I'm not allowed to do that. What I have to hope is that someday, because they're in default of their judgment, that if they ever get picked up on a criminal charge or a driving charge, that a bench warrant outstanding will show that they have to be returned to jail and then stay in court for the non-payment that they've not paid me. And then even if they say to the judge, okay, I'll pay them, they're not under any requirement to pay me. Understand, guys, in claims court, it's literally you owe that guy, you should pay him. That's about it. That's about it, just so you know. Sometimes it's not worth chasing. Was there another question? Because it is 12 o'clock and I didn't want to take anybody's lunch hour away from them. And if not, I know it's lunchtime. The court is not in favor of the landlord. That is correct, Melissa. Okay, I'm not seeing any other questions. So Tim, I will be out for lunch today and out tomorrow, so I will be back Wednesday. Well, Polly, just so you know, Wednesday's kind of iffy right now, and so is Thursday. We have a storm coming that promises to dump somewhere between 8 and 18 inches of snow in our area, which means I may have to be home sucking on down hot cocoa next to the fireplace before I come in here. And if that's the case, most likely you'll have to look at the website for the school to find out if there's an announcement regarding those schools. So I just want to let everybody know that's a potential issue on Wednesday and Thursday, just so you're aware. Yes, you can report to a credit department. I can't do it remotely. No, I don't have the bandwidth at home. My wife actually is an insurance broker. She works out of the home, and my system won't handle the two teleconferencing things. Okay, I'm going to take these classes a couple of times. Oh, that's a good idea. So anyway, we haven't even declared an absentee yet, so don't worry about rescheduling things. We don't reschedule. We just continue on our coursework. So I'm going to do this, guys. I'm going to leave you and be back at 1 o'clock. In the meantime, in the next minute or two, one of our administrative assistants, either Lauren or Noel, will come on and answer any administrative questions. You can ask them about protocol for the snowstorm, see what they say. So I'll be back at 1 and we'll pick up with the chapter and then finish it up and go on to chapter, where are we at? 13 when we're done. Okay. See you at 1.